To the first panel of the day. I'm Constance MacIntosh from Schulich. Our panel is Multi-Level Fisheries Governance and Food Security. And so we have three very forward-looking presentations you'll be hearing today about the evolving character of international fisheries law, evolving aquaculture regulation, and the potential of better enforcement in fisheries through the use of remote technologies. So our first speaker this morning is Dr. Stuart Kaye, who you see on our screen. Dr. Kaye has been the Director and Distinguished Professor of Law with the Australian National Centre for Ocean Resources and Security at the University of Wollongong since 2013. His doctorate in law is from Dalhousie University, yay, and he was awarded the Medal of the Order of Australia in 2024, King's Birthday, with honours for his service in international law and tertiary education. And Dr. Kaye will be speaking about multilateral fisheries enforcement. Can remote sensing technologies strengthen the prospects for more effective cooperation between states? So take it away, Dr. Kaye.
Thank you very much for that introduction. My only disappointment is I can't be with you all. I'm presently in Langkawi in the Indian Ocean in northern Malaysia, and if circumstances would have allowed me to get to Halifax in a timely fashion, I would have. I'll just share my screen and bring up my presentation, so if you can just bear with me all for a moment. It looks like it's just about to appear, and we should be away. Okay, what I'm going to be talking about this morning is looking at the way new technologies are beginning to have a substantial effect on fisheries enforcement and how this might help encourage greater cooperation between states. And I'm going to use the Pacific Island countries as something of an example in this regard. Now, what I'll start off with is to talk a little about the types of remote enforcement that may be possible, using the new technologies. One is to make use of UAVs, and particularly in surveillance and enforcement. These can be maritime or aerial, although the aerial are more common, and also the use of satellite technology. And I'll start off by showing you a little video. This is a current UAV, a current maritime UAV, and it's entirely autonomous. It steers itself. It is powered by the sun, wind, and wave energy, so it has effectively an unlimited range, and it can be tasked with a range of tasks. This one was out in all sorts of weather, having something of a rough old time. And it can do a range of things, including remain in areas where there might be fisheries issues and keep abreast of what is going on. It's also not very big, and so it can be loaded onto a trailer that a typical small truck could easily tow around. Now, this kind of drone is relatively cheap and can be deployed for all sorts of things. The people who are marketing this say it can be used for military applications, or it can be used in science. It's also being talked of to use in submarine cable monitoring. So quite the exciting piece of kit. More typical is something like this. This is an aerial surveillance drone. This is a Royal Australian Air Force drone, and this has a range of over 9,000 nautical miles, which means it could almost get from where I am now to where all of you are at 60,000 feet, and it would take over 30 hours to make that journey. In terms of costs and the like, you can see that compared to a patrol vessel, the utilisation of one of these sorts of drones is quite appealing. They're much cheaper to buy. They can cover a much greater area. They require fewer trained personnel, and they can be available much more often. So they're of great appeal. There's also increasing use of satellite technology. This is an oldie but a goodie. This is a heat map showing the location of fishing vessels based on their AIS data, which is the standard IMO data required for larger commercial vessels, but increasingly insurers require it to be on fishing vessels. And so you can see that although lines on the water for maritime boundaries and the outer edges of exclusive economic zones shouldn't typically be visible, we can actually see where they are based on where the vessels go. With their own GPSs, they can ensure that they don't enter places like French Polynesia there in the middle of the map. Similarly, this is one that shows what happened when Kiribati declared the Phoenix Island protected area, which is that square in the middle of the screen. Basically, it's like telling all the children get out of the pool, and they all jump out of the water, leaving you with an empty pool. This is just how extraordinary this technology is in terms of being able to see what is out there and how it's working. Now, all these tools are increasingly available at relatively low cost to states. A decade ago, this was the province of developed states who could throw lots of money at these issues. Today, the platforms I'm showing you with the heat maps can be made available to developing states effectively at no cost at all. And the cost of small drones and the like are substantially cheaper, as we've seen, than running patrol vessels. So these are particularly appealing to those in the Pacific. And the Pacific is a useful example because there's already highly developed and long-standing multilateral mechanisms for cooperation through what are called the crop agencies, the South Pacific Community, the South Pacific Forum Fisheries Agency, the South Pacific Regional Environment Program, and the Pacific Islands Development Program, just as the key ones in the context of fishing. Now, the areas that these organisations have sway over can be seen on this map, and if you think that each exclusive economic zone is going to be 200 nautical miles wide and out from side to side, that's going to be about 400 nautical miles, you get the idea that there's some pretty huge distances here in the Pacific. Australia is pretty big, and you can see it would occupy a relatively small part of this map. So the areas that these states need to surveil are huge. And the use of electronic communication, and to use that in a cooperative fashion, has been of great appeal. If you want a good reason why it's been of great appeal, this shows you how big the exclusive economic zones of 6 of the states in the Pacific are, how many patrol vessels they have at their disposal to go out and undertake enforcement. And you get the idea that if you're in Tanoi, which is the Republic of Kiribati's sole patrol boat, well, you've got to have pretty good eyes to get through 3.4 million square kilometres worth of exclusive economic zone to go out and undertake an arrest. And so for states like Kiribati and the Cook Islands and Tuvalu and the Marshalls, these are cooperation becomes self-selecting. You have to work together because you simply can't hope to get even close to doing what you need to do to protect these valuable resources. The way you do it is to work together and make extensive use of electronic surveillance. This is the main tracking room at the Forum Fisheries Agency headquarters in Honiara in the Solomon Islands. I was in that room about a month ago, although I didn't take this particular photo. But this photo shows you all the squiggles and lines on the globe behind them on the big screen. Each represent a fishing vessel. And this room provides data to states in the region so they can vector in patrol vessels and undertake arrests and do what they need to do to protect their valuable fisheries. They're also helped by regional partners. Before, in this part of the world, there was the Quad, which is the Quadrilateral Defence Coordinating Group, which are 4 developed states that are still present in the Pacific: Australia, France, New Zealand, and the United States. And they collaborate through a range of operations. Op Solana finished about a month ago, and Op Kurukuru is about to kick off. And these are basically concentrated patrols where these 4 states can bring their assets to bear to undertake support with respect to enforcement. Again, being vectored in using these remote tools. So we do it the old-fashioned way in some of these photos, but these are cooperative boardings. You can see there, these are 2 operations off the coast of Samoa. Now, the cooperation that these online remote material is able to bring is also enhanced through mutual enforcement. And this is done through the remarkable Niue Treaty, which allows for cooperative enforcement even in a state's territorial seas. All you have to do is have a subsidiary agreement in place, fly this flag when you undertake enforcement, and then you capture a vessel on somebody else's behalf and bring it into their ports for prosecution. This effectively allows for the mutual enforcement and prosecution across some 16 parties, which is the highest developed level of cooperation for maritime enforcement, as far as I'm aware, anywhere on the planet. Is it working? Well, this shows you in the lead up to the full implementation of all of these things up to 2010, that exploitation of tuna in the Pacific was really taking off, whereas tuna exploitation in the Atlantic was reasonably steady. Fast forward to the end of 2021, and we can see that the Atlantic, whilst improvements have been made, has a number of tuna stocks that are under great pressure. At the same time, although the Pacific experienced tremendous growth, it also was able to remain healthy, largely through this cooperation and the extensive use of remote sensing. So this really does work. To conclude, ultimately, states, when they have access to this types of remote technology, begin to appreciate the value that it brings in terms of monitoring, control and surveillance. It gives them a much better idea of what's going on in the fisheries around them. And from this, there's a natural step to want to get more of this data. And the easiest way to get that data is to work with others and make use of their data as well. And when you combine data sets, suddenly you can draw much wider nets. You can draw much stronger conclusions as to who the good guys and who the bad guys are, and make use of your on-water assets far more sensibly and effectively. Thank you all very much.
Next up, we have Dr. Jamie Baxter. He's an associate professor and the associate dean of research here at the Schulich School of Law, where his work and much of his teaching is on the legal and policy aspects of land, farming, and food. And today he'll be speaking to us about shellfish and sea plants as food. Lessons from regulatory reform. Jamie.
Thanks, Constance. Hi, I'm Jamie Baxter. Thanks very much for having me today. I'm going to talk a bit about shellfish and sea plants as food on the basis of a project I've been involved in the last couple of years around the regulatory regime in Nova Scotia. And I'll try and just draw on a few of those lessons for I guess, fisheries regulation more generally. I'm not an expert in fisheries. I barely know anything about aquaculture. I got roped into this project a couple of years ago, but I thought the theme was actually quite conducive to the event this week for a couple of reasons that I'll talk a little bit about. I do know a little bit about food systems, and that's going to be really the theme of my presentation for today. So here's really the question I wanted to pose to you all. The question is, what would it mean to regulate fisheries as part of the food system? Now, this is not necessarily a novel question. There are lots of folks who ask this question in different ways, but I think it's based on the recognition that, by and large, fisheries are not regulated as food or as part of the food system. That they are, regulated, one might say, as a natural resource, and all of the regulatory structures and baggage that comes along with that particular lens. My own experience of this kind of much smaller project around shellfish and sea plant aquaculture in Nova Scotia is that it may make a meaningful difference to regulate fisheries, or to approach the regulation of fisheries from the perspective of the food system. And therefore, we may have something to learn, or those who are interested in fisheries may have something to learn from those who think about regulation in the food and food system context. Okay, I'll make this a little bit more tangible. The outcome of the project that I'll give you a little bit of background on today was actually a legislative change in Nova Scotia. Last year, we were successful in getting an amendment to the Fisheries and Coastal Resources Act, to the purposes section, for the act to recognize as one of its purposes that fish harvesting, fish processing, and aquaculture industries are integral to the food system. Okay, now I didn't get everything I wanted in this one. I would have preferred it to say, in particular, integral to the regional food system, which is meaningful for me. But nevertheless, well, you know, the question is, this may or may not be a meaningful amendment to the Act. That is to say, it really raises the question, what would it mean to prioritize or foreground as one of the purposes of regulating fisheries in Nova Scotia, those systems, those activities and contexts as being integral to the food system. Okay. So that's another way of thinking about the question. The reason why I thought this was, you know, a good talk for today was really because it finds its genesis in what many of you will be familiar with, a report that was produced by our late colleague and friend Meinhard Dwell and Bill Leahy here at the law school on creating a new regulatory framework for aquaculture in Nova Scotia. So they were tasked really just before I showed up, or in the midst of when I showed up here at the law school a little more than 10 years ago, involved in what is really in my own mind, and again, I wasn't involved at the time, but I had a bit of a chance in the course of this project to look back, reflect on it a little bit. It stands to me as one of the really remarkable projects that has been, you know, coming out of obviously much of the work of MELAW and those that are involved in it. You know, there is much to still learn from what Meinhard and Bill said in the course of this report. So I won't go through all of that, but to say that there are sort of a fundamental tension, I think, that came out of, you know, what the provincial government did with this report with respect to aquaculture in Nova Scotia. On the one hand, you know, much of this report was about marine salmon aquaculture, you know, finfish aquaculture. Despite the fact that the mandate that Meinhard and Bill received from the province was really about aquaculture more generally. That is to say, it did include both shellfish and sea plants, but of course, the controversies of the time then and now were still much about finfish aquaculture because of, in particular, the environmental impacts of that sector. And for my purposes, when we went back to this report in order to think about what its implications were and should be for regulating particularly small and medium-sized shellfish and sea plant producers or farmers in the province, it seems to me that one of the things that got lost in the aftermath of the report and some of the regulatory changes that the provincial government introduced was this key point, that in developing our recommendations, we have been mindful that a regulatory system for Nova Scotia's diverse aquaculture industry must include or must reflect the differences between finfish and shellfish aquaculture, between large and small businesses, while strengthening the regulation of the industry in a comprehensive way. That is to say, the primary result, I don't think necessarily what Meinhard and Bill had envisioned, was the creation of, as many of you will know, an aquaculture review board in Nova Scotia, an adjudicatory tribunal, in which all forms of aquaculture got funneled through, particularly on the licensing side, which, as it turns out, I think had major implications for small and medium-sized shellfish farmers who wanted to get a license to farm 20 hectares of oyster or mussels, and we're simply and largely unable to do so because of the regulatory complexities that were involved in that. And in fact, I think there was only one or maybe two of those processes on the shellfish side that went through since the creation of the Aquaculture Review Board. Okay, so just very, very, very briefly, the implication of that, and I'm not saying the regulatory changes introduced by the government were the sole cause of these dynamics, but the shellfish aquaculture sector in Nova Scotia in particular, particularly when you look at those other jurisdictions that produce shellfish, or the farm shellfish, BC, New Brunswick, and Nova Scotia, PEI, Nova Scotia's production is orders of magnitude lower than those other jurisdictions, and I think there's a sense that much of that has to do with the regulatory complexity that sector has faced. Now, on the food side, and I'll get to food in just a very quick minute, this graphic is from a recent study that was completed, including by some folks here at DAL, that tried to sort of map the nutritional value of different seafood species against their relative greenhouse gas emissions. And the relevant part of this picture, without getting into too much detail, is bivalve farming is here in the purple, relatively low greenhouse gas emissions for not bad nutritional output, less than small pelagics and wild salmon, but relative to anything else you can do in terms of seafood harvesting or farming. Shellfish farming in particular, it looks pretty good from an environmental perspective, at least from a greenhouse gas emissions perspective. This is one of those sectors, if we were to look at the food system, if we wanted to consider not only encouraging for regional and local production, but also possibly for export, that is a pretty good bet, right? And yet, much of the impediment to developing this further has, I think, been regulatory in nature. Okay, and so our project was really to take a look at what would it mean to further reform this regulatory system, further fine-tune or maybe create some more dramatic changes from the system that emerged out of Bill and Meinhard's report about 10 years ago. And we were doing so from a food system lens. And to really ask, in this much smaller context, what would it mean to examine those regulatory changes or do what the provincial government wanted to do, which they said was right-sizing regulation for different sectors, to do that from a food systems perspective. And so, one of the changes then that we were successful in, I think, advocating for was then to take shellfish and seaplant licensing out of the ARB process, out of that adjudicatory review process, to put it into an administrative review process that nevertheless remains sensitive to some of these core concerns that Bill and Meinhard drew our attention to, which was things like social license, community-based decision-making, and environmental impact and so forth. Okay, so I don't want to talk too much about the project. I really wanted to make the point, or kind of raise the question as to how might you take the lessons from that kind of very small case study here in Nova Scotia and apply it to this broader questions around fisheries and fisheries management more generally, right? What would it mean to regulate fisheries as part of the food system? Okay, and so I think the big answer to me would be to center this idea around community food security, right? Not individual or household food security, not national food security, but a very particular concept around community food security, regulation that prioritizes access to healthy, safe, culturally appropriate foods through a sustainable, resilient, and equitable food system supporting community self-reliance. And this has certainly been a concept that's been picked up in food advocacy circles. It's one that's been applied predominantly at the local level around municipal advocacy in terms of the food system. And I think it's one potentially that could do a lot of work to help us think through what regulation might mean in the fisheries context. Okay, so with just a couple of minutes left, I'll just leave you with a few parting and very, very general thoughts, right? If I was to try to extrapolate some of what we learned in the context of this shellfish and sea plant farming project around what a food lens would mean. One is that system resilience requires harvesting or farming in the fisheries context at multiple scales. That is to say, if you want to build system resilience, you have to build in production, harvesting, farming at multiple scales. And what that really means, I think from my perspective, is to engage in a hard look at what I would call scale debiasing in regulatory systems. That there is, in most regulatory systems in the food context, an inevitable kind of movement toward capturing economies of scale. And that means larger units of production, bias against small and medium enterprises. And if we want that system resilience, we have to engage in those processes of debiasing. Number two, production can't be siloed from other food system nodes. I think this one is probably pretty apparent to everyone. I know it's something that fisheries thinks about, but my own experience, at least here in Nova Scotia with respect to aquaculture, it's regulated provincially here, it's regulated federally out in BC. There's very little what I would call good polycentric and collaborative governance taking place around aquaculture, at least in the shellfish and sea plant context, to be responsive to the needs of community, to the needs of farmers, and that food folks certainly think a lot about this. We have a lot of work yet to do in other aspects of the food system, but we really do take this idea seriously, and I think have something to offer about the struggles around trying to move out of the silos, right, that we see as being relevant to governing the food system. And then very finally, and this is the last point I'll end on, community self-reliance comes from rebuilding direct relationships around food. And I would call this one regulating in the margins. One of the things that we looked at in the course of our project was something that they do, for example, in Maine and is not yet available in Nova Scotia, a community food license, something like a community garden for shellfish harvesting. The ability to go out and get a small license for home or community production. And that's not going to make a big difference in terms of getting those numbers up or supporting the shellfish industry, but it is going to start connecting community members to what it means to harvest shellfish, what it means to farm in these contexts, to be connected to the aquatic environment. And in my own experience in the terrestrial world, that can go a long ways towards strengthening these kinds of direct relationships that are integral to community self-reliance. Okay, I will leave it there. Thank you very much for your time.
Thank you so much, Dr. Baxter. I had no idea there was that gap, and now I know all about it and what you're doing about it. So this is good news. The final speaker in this panel, our third doctor, is Dr. Cecilia Engler, who's a postdoctoral fellow for the Transforming Climate Action Through Law project at MELAW. Her doctorate is from Dalhousie University, and her research focuses on international comparative and national ocean law and policy. And she's going to take us through the complex story of international fisheries and the tangled web of international law.
Hi, everyone. Good morning, and thank you for having me again today. I am going to share with you some initial reflections on international fisheries law in the context of evolving and tangled international law. And I chose this topic for the MELAW Anniversary Conference because international fisheries law is something that is very tied to my history with MELAW. When I first came to Canada and when I first engaged with MELAW, first as a UN Nippon Foundation fellow and then as a master's student, it was precisely to study international fisheries law, study the United Nations Fish Stock Agreement and the work of the regional fisheries management organizations, which institutionalized the duty to cooperate for the long-term conservation and management of transboundary stocks, straddling stocks, and highly migratory fish stocks. At that time, I think it's fair to say that the main concern of regional fisheries management organizations was to determine who got to fish. The concern was to increase acceptance or ratifications of the United Nations Fish Stock Agreement, to ensure compliance and enforcement, to eliminate IUU fishing, and to also resolve the issue of participatory rights and allocation of quotas. In a workshop that was held here in the fourth floor of this building, a senior officer of DFO mentioned at that point that the main concern of RFMOs, or the only concern of RFMOs, was allocation, 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 referring to the allocation of quotas. This was also the time where the International Commission for the Conservation of Atlantic Tunas, ICAT, was also known as the International Conspiracy to Catch All Tuna. So RFMOs were perceived and to a large extent behaved really like fishing clubs. But international law, international fisheries law has evolved from that time, and I'm carbon dating myself here, but so has international law. There is increasing evidence that the triple planetary crisis is highlighting the linkages of issues or elements that so far or in the past have been addressed in a silo manner in international law. Climate change in particular is exacerbating the pressures on marine biodiversity, is also exacerbating existing and historical patterns of vulnerability and discrimination. So the question I have is, I should add that those linkages and the need to address them holistically by international law has been recognized and somehow embedded to different extents in binding and non-binding agreements, for example, in the Paris Agreement on Climate Change and the Global Framework on Climate Resilience, in the BBNG Agreement, in the Global Biodiversity Frameworks, in the 2022 United Nations Declaration on the Rights to a Safe, Clean and Sustainable Environment, which also applies to oceans as further developed by a human rights Special Rapporteur, and most recently this year by a resolution of the Human Rights Council. So the question I have is, if this tangled web of international law that is developing, how is it reflected in the work, in the implementation, in the interpretation and implementation of the United Nations Fish Stock Agreement? And this is not just a very theoretical question, because actually the provisions of the United Nations Fish Stock Agreement itself recognizes, addresses, or at least allowed to address some of those elements. And I don't want to be a full legal analysis here, but Article 5 on general principles that have to be implemented in the conservation and management of highly migratory fish stocks and straddling stocks, and that apply also mutatis mutanda in the exclusive economic zone, recognizes, for example, the need to address the impacts of environmental factors, which includes climate change, on target stocks and associated species. It also includes the obligation to protect marine biodiversity and to take into account artisanal and subsistence fisheries, which are further developed in other provisions of the United Nations Fish Stock Agreement. So how are those developments in international law helping to interpret those provisions? Fortunately, the United Nations Fish Stock Agreement itself provides a very good basis to assess that, at least in the first level, because Article 36 of the UNCSA establishes a review conference, and the state parties to UNCSA decided not to close that review conference, but just to suspend it, resume it on a periodic basis, more or less every 5 years, so they can continue to address the challenges of our RFMOs, but also address new and emerging challenges. So that provides a very good timeline of how the discourse and the narratives have evolved within the United Nations Fish Stock Agreement. And I should add that is actually a very timely exercise this year, because we are celebrating the 30th anniversary of the opening or the adoption of the United Nations Fish Stock Agreement. So at a very high level, I address how many times each of these elements, biodiversity, climate change, and the human dimensions, or the human dimensions or human rights, are considered in the reports of the review conference and in the outcomes of the review conference. Not only those terms, but also associated terms. And as you can obviously see, all of them have been increased in the number of times that they have been cited in the report. However, looking now at what is being discussed, the analysis is a little bit more nuanced, and I want to give you just two examples of that. So when addressing climate change, the first time that the review conference addressed climate change was in 2010. And from one single recommendation to strengthen the efforts to review and assess the effects of environmental factors, including climate change, on target stocks, and to, where possible, consider those impacts in implementing conservation and management measures. Today, in the last review conference, there are a number of recommendations to address climate change. And that may be very encouraging, but what is more important is what was not included in the last report. Most of the state parties to UNCSA endorse a stronger language to address climate change, but a consensus could not be reached. For example, there was no consensus to include a recommendation to adopt climate adaptive fisheries management plans. There was no consensus to include a recommendation to assess the institutional barriers for RFMOs to address climate change. And even the when it comes to incorporating climate change in the decision-making processes in the conservation and management measures adopted by the RFMOs, the language was softened from mainstreaming climate change to just explore ways to incorporate. So there is progress, but it's a hard-won battle by the states that are trying to make progress to integrate other elements of international law in the context of the UNFSA. Another example is the social dimensions that I found particularly interesting, because originally the RFMOs paid scant attention to the social dimensions of fisheries. There was some mentions of the need to provide or to assist developing states in providing access to the fisheries, but that was just a repetition of a provision that is already in the United Nations Fish Stock Agreement. In the 2023 review, you can see a whole bunch of very detailed recommendations to enhance the capacity of developing states. Includes recommendations, for example, for states to adopt standards for labor conditions of the crew on the ships. Several measures to strengthen the capacity of developing states to participate in fisheries. But also, I found striking, there are several recommendations for states to support directly subsistence, small-scale and artisanal fisheries, indigenous people in developing states, and support them in several ways. Number one, to participate in regional, in the meetings of the regional bodies or other international fora, but also support them in avoiding impacts on these groups and facilitating access to fisheries to those groups. And one last measure that I want to mention is that the parties there agree that there is a need to develop as a matter of urgency the concept of disproportionate burden in the context of an article that calls to avoid disproportionate burden of conservation action onto developing states. So again, there is progress. Hard-won battles by states deliberating in these conferences. What I can offer as preliminary conclusions of this research is, number one, that the review conference is serving as a valuable instrument or avenue to integrate international law, broader developments of international law into the international fisheries law. There is also, it's a valuable instrument to put focus on some provisions of the United Nations Fish Stock Agreement that have so far been neglected. It has been a contested process, it's a difficult process, but progress is being made. And that the real question is whether these recommendations are going to remain as words in the review conference, or if they are going to be implemented. And that would be a second step of the research to assess how they are actually being applied and implemented in the context of regional fisheries management organizations. Thank you.
Thank you so much, Dr. Engler. So we have time for some questions from the audience in person or online. Our online situation is being watched to see if questions come in there. So who would like to take the first question? Go for it. Get ready, everyone.
Stuart, David Bass, right here. Good to see you again. Australia has a huge area of Antarctic, the Southern Ocean, and I know you're focused on South Pacific today, but could you make a few comments on how Australia is dealing with these technologies over the Southern Ocean, because it's a vast area.
There, but I think I'm being asked to talk to use of this technology in the Southern Ocean. To some extent, the Southern Ocean isn't quite as amenable to some of these technologies, simply because satellites typically are orbiting above the Earth over the equator, and so the imagery from far southern waters is limited. And the use of drones in those waters, well, you're really going to find out if your drone can survive a storm if you send it down there, because you're looking at swells of in excess of 5 metres on a pretty regular basis. So ultimately, the remote technology is useful, but it's at a higher end at this point. You really need some extra kit to get it to work there, whereas a lot of the stuff that you can use in the equatorial regions of the Pacific are much, much better. To some extent, the Southern Ocean, I think, has benefited more from things like port state control and also market-based measures to try to limit the access of sellers of things like Patagonian toothfish into markets. But the technology will get better in the south and hopefully can be more widely used. In relation to transfer technology, I know the Law of the Sea Convention in Part 14 had some quite extensive provisions that have largely not really resonated and not been as effective as they might. But in the context of this maritime enforcement technology, I think that the opposite is true. Developed states have been quite willing to share access to this technology to help developing states make use of it and to help make their monitoring, control and surveillance systems far more robust. And it's not really been stated in those terms because I guess states don't want to talk about what enforcement capabilities they have, because that just tips off the baddies as to what steps they might take to mitigate against them. But it has been a success, and I think it's wonderful, because a lot of the technology transfer stuff just never happened, and it's a minor tragedy that it never did. So it's great that this has occurred, and I thank you very much for the question to draw that out.
Jamie, community food security and sovereignty, can you share some thoughts, please?
Sure. Thanks for the question. And I mean, very briefly, I mean, I think the short answer is there's a lot of mutual kind of overlap and reinforcement between, you know, this kind of core concept of community food security and food sovereignty. And so, you know, in terms of that aspect of community self-reliance in particular, I think there's much resonance, and the idea of food sovereignty certainly has been picked up and really taken up by the food movement and made very central. Now, I'll just say, like, very briefly, I have my own worries a little bit about how that might develop in this context, because we're starting to see some of the discourse around food sovereignty, you know, be appropriated for, I think, political purposes that I think it really wasn't originally envisioned for, in a way that was based more around the community aspect and taken up as a kind of, you know, resistance to any kind of government regulation at all. This has been really kind of prominent in the US recently. And so I think we're in a bit of a time of flux in terms of trying to understand and make sense of how to think about that concept of food sovereignty in these particular contexts like fisheries. I think, you know, for my own part, that idea has always made more sense to me, and Sherry, you'll have more to say on this than I would, around indigenous food sovereignty, for example, in the broader sense of food sovereignty within the food movement. I think that is a thing we're going to see shift a little bit and have some tension around the next little while. Yeah.
Thank you, and I will invite Sherry to comment on this question as well in a moment, but first I'd like to hear from, or I'd like to give this an opportunity for Cecilia to speak to us on international fisheries law and fishermen's subsidies.
Yeah, thank you for that question, I guess. I would say that my presentation tried to focus on basically the climate biodiversity people nexus. So there are a very large number of other developments that have occurred in international fisheries law that I did not address because they didn't fall within that trifecta, basically. So there's been a lot of progress in different ways to address, for example, IUU fishing with a new port state agreement and gentle force of the compliance agreement. There are voluntary guidelines on transshipment developed by FAO. So there is many other developments, but I don't consider them necessarily within the trifecta of biodiversity, climate, people. Not that they are unrelated, of course, everything contributes to better fisheries governance, but that's why it wasn't included in my scope. Yeah, that's, I think, what I can say.
Thank you so much. I'm just going to take the 2 questions online and then ask Sherry. I really am interested in hearing your views, so I'll pop this over to him. But first, there is a question for Cecilia online, and the question is, as the ITLOs adopted the advisory opinion on climate change issues last year, is it possible that the UNFSA next review conference reemphasizes and goes further on the issue and measures about climate change? This is a complicated question. And in that case, is it possible that the RFMOs adopt more concrete measures to combat climate change? So a bunch of embedded hard questions again.
Yeah, that is one of the developments that has happened that I did not mention explicitly, but of course the law, the International Tribunal of the Law of Sea recognizing basically mainstreaming climate change into the provisions of the convention should have an impact on the way that parties implement not only the convention but also related agreements like the UNCSA. I think it is, as I said, it is a hard-won battle. There are steady steps to include climate change considerations into fisheries arrangements. That has happened not only in the review conference, but also in individual fisheries management organizations with a lot of uneven treatment. Several studies have addressed that, including some led by David van der Zweck. But yes, for sure, it's one of the developments that should be included in the review conference. Now, if that will lead to stronger measures, considering the opposition of really a few states to stronger measures and recommendations to states, that's a different question. The other question is, if there is no consensus in the review conference, that doesn't mean that a particular regional fisheries management organizations that have more like-minded parties may make faster and bolder progress.
Okay, wow. And question for Dr. Kaye. Is there any indication that technology such as drones is affecting the behavior of marine life, including predators of fishing stock?
Look, I'm not aware of any adverse effect caused by drones. Obviously, the aerial drones shouldn't have any significant effect on marine life. The on-water drones, the little one I had the video of is the size of a large canoe, so they're likely to be less invasive and disruptive to marine life than other activities. And all up, the use of this technology, including the satellites, is to try to have vessels that are on the water targeting where they need to be a lot more effectively, which hopefully means that they're out stopping illegal activity with hopefully the minimum amount of disruption to marine life. So I'm not sure there's a downside for this, but if there are studies that suggest otherwise, I'd be happy to hear about them.
Thank you so much. Sherry, do you just want to weigh in a little bit there and help us understand the...
Very interesting, you know, my meeting was canceled today, which allowed me to be here in the city of Tangled for a reason. I was really intrigued with all the presentations of Cecilia. Thank you so much for referencing the small-scale fishery guidelines. And I was thinking, Jamie, I've been working on some administrative stuff, and I never knew that you were doing this work, because I say the same thing. I don't know anything about fish, but the Donald Marshall Jr. case, it's taken over my life for the last 27 years. But I was just wondering, you know, I was thinking, gosh, I wish I had that report back in 1999, because as you know, the court cases divide food fishing, which is such a hassle, from the livelihood. And I was just wondering if there was any crisscrossover in your work in that sense, like let alone all of the bureaucracies that how our legislation differs from those in British Columbia. But I just wondering that was that an issue in terms of trying you know, promote this idea of developing a relationship with shellfish?
Yeah, that's a good question, Sherry. And I mean, I've thought about it in the sense that distinction always seems strange to me, right? When you again look at it from a food perspective, you know, the idea of just kind of production for personal home use versus some kind of commercial production, those lines get quite blurred, right? When I think we adopt the food lens. I haven't thought about it more than that, other than to recognize how strange that does seem when you sort of start to look at it from a different perspective. But it seems like it could have some pretty major implications, right? If you could kind of try to shift that conversation a little bit.
Yeah, because the industry has been so privatized.
Yeah.
Well, I'm talking about fisheries broadly.
Sure.
So privatized in the last decade in terms of, you know, there's companies that basically run the show. It's been so difficult because you're right, the fish, you know, is looked as a commodity, and that's it.
Yeah.
And no one looks at it as a relationship to the food until after it gets to the market. And this has been a big, huge issue for Indigenous folks. That why can't they fish for food and for a livelihood? And those two are not allowed, not in Canadian society anyways.
Yeah.
So, you know, on the food sovereignty front, there is going to be the third Nalini gathering. I think it's now going to be in Sri Lanka this year. But our issue from an Indigenous perspective, not all Indigenous people, not speaking for white people, is looking at natural resources or the natural sources of food, such as fish, and getting them recognized as food. You wouldn't believe that it's such a hard thing. And the only way we were able to accomplish that was in the small-scale fishing guidelines.
Yeah.
Like, those are some thoughts.
Yeah. The thing I just noticed is I went back and I was looking at the Minority Bills report, and food isn't mentioned at all in there. You know, it's kind of remarkable when you start to think about it that way, because it seems obvious when you say it, but nowhere in any of that, or any of the multiple reports that have followed, is in that case aquaculture or fish or shellfish even talked about as food. I couldn't find the word at all.
Well, look at
Which
the
is
food inspection agency,
Yeah.
which I gave a presentation to not too long ago. They don't have to put that it's GMO. It's just as long as the fish is safe, safely produced. They don't have to put where it comes from or anything.
Yeah.
Right, yeah. But anyways, it's very interesting.
Thanks, Sherry.
Thanks so much. And I did send a copy to my chief.
Okay. I would like everyone to join me in once again thanking our three brilliant panelists.